This test is just between you and me. You'll be better off if you talk to me. I'm Andrew Flushy, and I'm here to protect you on the roads of Virginia. Before we get into this video about the shit police say, let me first take a minute to say that this video is not about berating the police. Sadly, people fall for a lot of their trickery, and it helps the police make their case against you and sometimes may incriminate you in a crime that you didn't actually commit. So let's look at some of the shit cops say to make their case. Number one, will you do some tests to make sure you're okay to drive? What they're really saying is, I want to see if I can arrest you for DUI. You need to understand that field sobriety tests are voluntary. You do not have to do them, at least in Virginia. And when the officer says, you don't mind doing some tests for me to make sure you're safe to drive home, what they're really saying is, I want to see if I can arrest you and get another DUI to try to get a MAD award. And that's a lot of times what's going on here, is the officer is doing his job, but trying to see if you're impaired or not. And if you're impaired, you're going to get an arrest for DUI most likely. Now, sometimes officers let things slide if you're super cooperative and they feel for you. But most officers, if they can arrest you for DUI, they will. So when they say, you don't mind doing some tests to make sure you're safe to drive home, now you know that's really code for, I want to see if I can arrest you. And frankly, unless you know that there's no possible way you're impaired by anything, you should refuse field sobriety tests. Now, if you've never not had anything to drink, no substances in your system, legal or illegal, maybe it would be okay to do a test to prove that, to get yourself out of there quickly. But in most cases, the tests are frankly difficult, and different medical conditions, physical conditions, mental conditions you may have can make it difficult to do those tests, even if you haven't had any substances in your system in days. So generally speaking, my rule of thumb is refuse all roadside tests. Number two, the judge will probably dismiss this. What the officer is really saying is, I'm trying to placate you to keep the situation calm, but I'm going to write you this ticket or charge you or arrest you. If the officer's saying, oh, this isn't a big deal, the judge will dismiss it or make it go away when we get to court, why is the officer even writing you in the first place? They don't have quotas. That is kind of a misconception. They certainly are expected to have contact with citizens and do their jobs, but there's not certain numbers they necessarily have to reach. So if the officer is writing you a ticket, it very well may not be dismissed. And so don't fall for the lie that the judge will probably just make it go away. Now, if we're talking something simple like maybe an inspection sticker, and the officer says, hey man, you know, I've got to write you for the sticker because it's expired, but if you bring proof to court, the judge will probably dismiss it. That's probably not a lie. The officer's probably telling you straight up what he believes will happen. The problem is the officer is not the judge, and you don't know for sure what judge you're going to have until you get there for the case. So maybe the normal judge will dismiss it, but you may show up and have a substitute judge, and the officer, his whole idea that your case will be dismissed may be out the window. So don't take that to the bank. It's definitely wise to talk with an attorney, even for a minor ticket, to see if it's really likely to be dismissed or not. Number three, it'll be easier if you just admit where the drugs are. What the officer is really saying is you're going to make his job easier by proving his case and admitting that you were in possession of the contraband. To be guilty of possession of drugs, the Commonwealth has to prove that you knowingly possess the drugs to some degree. It's kind of complicated and too much for this video. However, they have to prove knowledge, basically that you were truly in possession, not just that they were somewhere in the car that you happened to be in. So if the officer pulls you over and suspects there's marijuana in the vehicle or some other drug, and he says, okay, if you just admit it's going to be easier on you, what he's really saying generally is that you're going to make it easier on him to prove that you actually knew the drugs were there. So that's one thing to keep in mind. Admitting to things, maybe it will go a little quicker and you'll get to work, but the officer can likely prove his case if you admitted that the drugs were there, even if they're eventually going to find them anyway. Just if let's say you're pulled over and you know that there's some stuff in your car that shouldn't be there, and he says, come on, we both know there's something in here, you should just admit and make this easier. Really, admitting is basically proving their case and admitting that you did know it was there. If they find it on their own, they then still have to tie that to you and prove that you actually knew of the nature of the substance and knew it was there and had some control over it. And just because it's in the same car with you or in the same room with you does not mean they can prove possession unless you admit. Number four, you'll be better off if you talk to me. That's really code for you're going to make the officer's job easier by confessing. Now this is sort of a corollary to the point we just talked about admitting to the presence of drugs. The same thing goes to any violation. If you're the suspect of a crime, you have the right to remain silent. Even if the officer hasn't told you yet, you always can remain silent when you're a suspect. And even if you're not sure you're a suspect, if you have no idea why the police are asking you questions, you very well may be a suspect. Now, you can't lie if the officer is asking you questions about somebody else's crime. If you're not a suspect, if you're just a witness, you can't lie. You still don't have to talk. So you always have the right to remain silent. And frankly, that's the best policy, especially if you know you may be in trouble for something. The best policy is to remain silent and simply don't answer questions. You don't have to give them a reason why you're not answering questions. You can simply close your mouth. Remember, like we did in grade school, zip your mouth and throw away the key and just remain silent. That's usually the best policy, especially if you know there's some reason that you're a suspect for a crime. Keep your mouth shut. Number 5, you don't have anything illegal in the car, do you? What the officer is really asking is, please point out your contraband so I can charge you for it. That's kind of a loaded question, right? I mean, most people want to say, no, officer, I don't have anything illegal in the car. But then sometimes people will just go ahead and think, well, they're going to find it anyway. So yes, officer, I got just a little bit of weed here. And what happens a lot of times is maybe you'll think, well, all I've got is this little bit of weed in my console. They're going to see it anyway. But then admitting that it's there, that now gives them permission to search the whole area and your person for other weed or contraband. So you've just opened up a whole can of worms that may have never opened up in the first place. The officer may not have suspected anything. He may just be asking a routine question that he asks in every speeding stop, and you've just given him reason to search your car and charge you with a violation of the law. So admitting that there's anything in the vehicle, that is never a good idea. Or the same thing, if they knock on your door and say, hey, we got reports of such and such, you don't have anything illegal in here, do you? It's the best policy just to say, I don't want to answer any questions. That's a great way out of it. Number 6, and probably my biggest pet peeve, this test can't be used in court. What the officer is really saying is a flat out lie. This test will be used in court every day of the week. This lie comes up in DUI cases all the time. The officer has pulled you over for some reason. He has had you do physical tests where you've walked the line, doing the 9-step walk and turn. He's had you do the one-leg stand. He's had you follow the pin with your eyeballs, doing the horizontal gaze and nystagmus. And now he's asking you to do the culmination of all his tests, the preliminary breath test. And what some officers will say is, you know, you have the right to refuse this test. It's no problem. This test is just between you and me, so it gives me an idea of where you're at. And a lot of people rightfully pause and start asking questions and trying to figure out, well, what are the consequences if I do or don't take your little test? And the officers will generally not give you a whole lot of guidance, but sometimes the officers will go in and say, look, this isn't just between you and me. It's not going to be used in court against you. You know, this just gives us an idea. You know, I already have formed my opinion of where we're at and whether or not I'm going to arrest you, and this test can only help you at this point. That is just a flat out lie. All right? That test can absolutely hurt you. The preliminary breath test is a tool for the officer to determine whether or not they can and will arrest you. If you blow an 08 on the test, generally speaking, most officers are going to arrest you for DUI, no matter what your physical tests were. You could have aced the physical tests, and most officers are still going to arrest you. There are a few who would say, well, you're an 08, you did really good on my test, let's get you a cab. But a lot of them are going to arrest you. And the biggest part of this lie is that the preliminary breath test can and will be used against you in court. It cannot be used to prove that you're actually guilty of DUI. However, it can and will be used if you challenge the arrest. So if you and your attorney fight about whether or not the officer should have arrested you in the first place, the preliminary breath test will be able to be used against you. Now, there are arguments to try to keep it out of evidence, and that's a whole other video. But the key part is, it is simply a flat-out lie that this test cannot be used against you in court. Now, it cannot be used against you in your trial to prove whether or not you're guilty, but it can be used in court, and that's the whole point of it, is to prove that the officer was justified in arresting you. So this goes back to my earlier advice that if you've had anything to drink that day, you frankly should refuse the preliminary breath test. The officer may still arrest you, but then he'll get you down to do the real breath test, and you would be a very, very low number. If you had one drink, 6 hours ago, it's probably not going to be in your system at all. And if it is, you might have an 01 once it gets you to the main test. And you should be released at that point. So this goes back to my earlier advice. I normally recommend, in Virginia at least, always refusing roadside physical tests, searches, and breath tests. You have the right to refuse them, and generally speaking, they are only going to hurt you. For a story about a client who was badgered into doing all these tests and ultimately beat her case, check out the next video.